So Besigye, Dr. Besigye, first of all, was abducted from Kenya without following due process. The only circumstances that a citizen of Uganda can be arrested out of Uganda is when you are wanted to answer to charges and there's an arrest warrant, yes. And that involves Interpol to arrest you wherever you are, yes. And bring you back. Once this is done, then the extradition process is followed. In that extradition process, the country where you have been arrested through court. Well, I think the whole environment for practice of advocates under the court-martial, but also the reason that takes them there, the trial of civilians in court-martial, needs to be reviewed. Under the doctrine of separation of powers, the executive should concentrate on service delivery. The army as a pillar of state falls under the executive, and their job is protection of the territorial integrity of Uganda and sovereign rights of Ugandans through national security. The role to administer justice under Article 126 of the Constitution, yes. Belongs to the judiciary. The legislature does work of lawmaking, budget appropriation, and oversight. So once we have a fusion of the executive wanting to administer justice through the army, then we have a crisis that we have been driven into through the dilemma in the court-martial. Ideally, military courts are meant for discipline of officers of the army, the same way we have police tribunals. Have we ever found a problem with police tribunal in this country? But when the police officers are out of line, they are dealt with under their disciplinary courts. So this should be the same way that we look at military courts as a way of instilling discipline within the military soldiers. That's why military courts sit in the field. You make a mistake in the operation, they sit one day, and we don't have a problem with that. Deal with the soldiers. So, but when it comes to dealing with citizens, we have a problem with that. We have a problem with the UPDF trying to make itself into an appendix of the judiciary, because that violates the principle of the doctrine of separation of powers. There was a mistake that was made in the UPDF Act to say that when civilians are caught in conditions that look like those of the army, then you try them in the army, which was a big mistake by the parliament then. The court in Banjul, the African Court for Human and People's Rights in Banjul, ruled in 2014 that Uganda should amend the UPDF Act and remove all clauses that concern citizens. Okay. Uganda government has failed to do that. Our own constitutional court has ruled twice that it is unconstitutional to try civilians in military courts.
So why are we...
The Supreme Court has become a thick neck towards this problem instead of being a solution. Let me tell you, we don't know the circumstances through which advocates were facing in this court. These are advocates that are trained to work in civil courts, where laws are respected, where everybody respects themselves, and where everybody keeps in line, in their line. But they find themselves in a strange territory because the court is dragging civilians into their arena. So you can't tell what has happened unless you are fully aware of the facts. Okay. I cannot say that Council Aaron Chiza was out of line. Okay. I don't know what happened. We have seen several times the military court manhandling civilians, manhandling advocates in these courts. But also, if I may go, because I am not fully aware of what transpired, but if I may go to the charge, you know, the contempt of court is a charge that is a preserve of judicial courts. The military court, which is a tribunal, trying to invoke this case as if they have also powers to handle matters of contempt, is in question. It is something that should be understood. Because if you are a military tribunal, are you a court that can be contempted? Determination of the Supreme Court case. Okay. The framers of the UPDF Act in 1995 made a mistake. And fair play of the executive trying to play a double role of the judiciary, which conflicts the doctrine, as earlier explained. Yes. This mistake should be rectified by Parliament. The UPDF courts, whether they want to call themselves courts or whether they are tribunals, should only deal with matters of discipline. Even as a serving soldier, if they commit crimes that are beyond operational mistakes, omissions and commissions, these crimes should be handled in civilian courts because they are, first of all, citizens of this country. If, for example, a soldier, these who are engaged in robbery, they are always in civilian courts. Why aren't they in military tribunals? So Besigye, Dr. Besigye, first of all, was abducted from Kenya without following due process. The only circumstances that a citizen of Uganda can be arrested out of Uganda is when you are wanted to answer to charges and there's an arrest warrant, and that involves Interpol to arrest you wherever you are and bring you back. Once this is done, then the extradition process is followed. In that extradition process, the country where you have been arrested through court confirms that your rights will be respected in that country. If there is any evidence to prove otherwise, you're not handed over. We can follow the extradition trial of Jamil Mukulu that took 6 months in Tanzania. Yes. Jamil was a wanted terrorist. But they couldn't just pick him and bundle him the way Besigye was picked here. So it is alleged that Besigye was engaged in acts aimed at undermining national security. What does this mean? The duty to maintain the security of the country belongs to the army. So this makes the army the complainant and witness in Besigye's case. His trial in the military court makes the army the investigator, the prosecutor, the judge, and the jury in the same case where they are a main complainant and interested party. So the army, before you don't, even if you were a child, the interest of the army is to convict Besigye. Because the army is an interested party in convicting Besigye. So Besigye cannot get a fair trial as guaranteed under Article 28 of the Constitution and also protected under Article 44. He cannot get it in this court. So what is going on there in that court right now? The military court, unfortunately, is being used as a tool for oppression and political persecution. If indeed the army is genuine, that they have a case against Besigye, we have a special court for crimes, war crimes, because they allege Besigye was planning a war. Let him be tried in the war crime division of High Court. What are they hiding? In that military court martial, where a chairman is a layman, and the anger to arrest Aaron could have arose from the way Aaron was saying illegal concepts, basic illegal concepts, that the people could not understand in the previous appearances. And maybe they saw it as a challenge, and as military, all they know is fighting back on challenges. Because if somebody, you know, the concept of court challenge does not have a punishment, a written punishment. It's left at the discretion of courts. We have so far had 2 crazy decisions or punishments for contempt of court. The first one was for Marema Vilizi by Justice Sekana, and I know the Law Society is investigating Justice Sekana for judicial misconduct. But now the second crazy one is from a military tribunal of 9 months. Usually a contempt of court, it's either a fine or suspension from 1 or 2 appearances. It has never even made the news.